If you think owning your house outright, having no mortgage, is ultimate protection at retirement, what I'm about to tell you next will shock you. You see, a paid-off house in Australia is not protected from being quietly transferred into another person's name. Australia has had proven cases of exactly this, with the most famous one in Canberra, where an investment property sold without the owner's knowledge while they were living overseas. And from the age of 60 onwards, I can tell you the consequences of not knowing compounds exponentially. I'm not trying to scare you, I'm trying to explain why 5 preventative actions exist and why most Aussies over 60 have never heard them. I spent the better part of 4 decades inside the Australian social services. Since retiring, I've been volunteering with the Financial Information Service, sitting across a small table from people in their 60s, 70s, who have done everything right. They've paid off the mortgage, saved for many decades, then scams strike like thunder. Scams that could have been prevented for the price of a phone call and a couple of forms. There are 5 gaps I see often and 5 actions you can take to close them. Let's begin with 2 actions that take the least time. First is the title reference alert. Your home is on a live electronic register at your state's Land Titles Office. The Registrar General's Office in New South Wales, Titles Queensland in Queensland, Land Use Victoria in Victoria, Landgate in Western Australia. These offices process applications to change titles, transfers of ownership, and transfer of mortgages. What the registry can't do is ring you first. That's how property title fraud thrives. It doesn't look like a home invasion, it looks like a form. Some fraudster identifies a paid-off home with an elderly owner. That search takes about 45 seconds and it's legal. They pull the title details, forge identity documents, and lodge a transfer against the property. Most state land registries now run a low-cost monitoring service. In Western Australia, it's called Title Watch through Landgate. In New South Wales, there's a title alert service through NSW Land Registry Services. Queensland and Victoria have their own equivalents. The mechanics are roughly the same. Go to your state's website, create an account, enter your title reference. From then on, every time something significant is lodged against your title, you receive an email notification. I set it up on my own place in Mildura after I retired. I'm not the most tech-savvy person in the world, but it took less than 15 minutes. One thing to know is that the alert does not block anything, it just informs you. If you receive a notification you don't recognize, ring the State Titles Office immediately. I have not authorized this and it's fraudulent. They can place a hold while they investigate. Speed matters. Do this today. Now for the second action. It's called a caveat. It's a caveat that you, the owner, lodge on your own title. This sounds odd because most people associate caveats with an ex-partner. When that caveat is in place, no transfer, no new mortgage can be registered without the caveat first being addressed. The fraudster who has forged your signature has to fight a notice that says, "The registered owner has flagged this title. Do not proceed without contacting them directly." That is a much harder barrier to slip past than a clean title. You can lodge it yourself or use a solicitor. The solicitor will need to verify your identity in person, which is the goal of the protection. The third action has nothing to do with fraud. It's about what happens in your family when things go wrong. Most Aussies assume that if they had a sudden stroke or dementia diagnosis, their spouse could step in and manage all the bills and bank accounts. That's false. Without a registered enduring power of attorney for financial matters, and in most states, a separate enduring guardianship document for medical and lifestyle decisions, not even your spouse has legal authority to act on your behalf. The fallback is an application to administrative tribunal like VCAT in Victoria. Those applications take months and sometimes years. An enduring power of attorney names someone you trust to act on your behalf if you lose capacity. The document and process vary state by state. In Western Australia, it's an enduring power of guardianship for the lifestyle side. In New South Wales, you appoint an enduring guardian. In Queensland, the two are combined into a single form. The public trustee in most states will draft a basic enduring power of attorney for a fee in the low hundreds, sometimes free for full-age pensioners.
A solicitor will definitely cost more, but you get what you pay for.
I sat across from a man last summer. Let's call him Noah. Noah is 71 and lives in Geelong. His wife, Jill, had had a sudden stroke.
Jill managed their home's paperwork for almost 50 years. Accounts were in her name. Noah didn't even know who their electricity provider was or the password was to their Optus email. They had wills, but no enduring power of attorney.
It was 3 months that Jill was in hospital and then in rehab. All the while, Noah had no legal access to their bank accounts and he couldn't pay the bills. Jill recovered, but when he came in to see me, he was humiliated. "Why did nobody tell me about this?" he asked. I didn't have a good answer. But take this as a lesson and take these 3 actions before scams strikes like lightning. The 4th action is about a decision you make right now. You see, most Australian couples own their home as joint tenants. If you've never specifically been told otherwise by a solicitor, that is how yours is held. Joint tenancy has a simple rule. When one of you dies, the other takes the whole property through survivorship, regardless of what the will says. When the first spouse dies, the surviving own has the entire home in their name. If they later need residential aged care, the family home enters the means assessment in a very specific way. Under the rules from the 1st of November 2025, for anyone entering residential care, the principal home is exempt only if a protected person, a spouse or a dependent child, is still living there. If there's no protected person in the home is included in the assets test up to a capped value, currently around $210,555 as of September 2025. That cap is the part most families miss. People think the home is fully exempt. It isn't, unless someone protected lives in it. What that translates to is a higher hotelling supplement contribution and, for many residents, a higher non-clinical care contribution. The system introduced from November 2025 has lifetime caps and 4-year limits, but the cash flow pressure in those first years can be significant. A single resident with assessable assets above roughly $501,000 starts paying meaningful means-tested contributions. Above about $1,020,000 in assessable assets, they hit the maximum daily contribution. I sat across a woman called Heather, 74, recently widowed. Her husband had made a will and spent his last weeks reassuring her their kids would be looked after. The house was held as joint tenants. By the time she was sitting across the desk from me, the survivorship had already happened. The whole property was in her sole name. Everything he had carefully thought about was now sitting fully accessible, fully exposed in her hands alone. One decision could have changed that, severing the joint tenancy. It can be done through your state land titles office to convert the ownership from joint tenants to tenants in common in defined shares. Usually 50-50, but it can be other splits. It's a straightforward form and a modest fee. Something else that could have been done is to update the wills to include a testamentary trust, sometimes called a life interest or a protective trust. When the first spouse dies, their share of the home does not pass outright to the survivor. It passes into a trust. The survivor has the right to live in the property, to sell and downsize if they want, but key is that the deceased's share is held by the trust and not in the survivor's name. It's treated differently for aged care assessments compared to an asset they own outright. It doesn't remove all exposure, but it's better than nothing. And the trust inside the will needs to be drafted carefully by an experienced solicitor. A clause copied from the internet won't cut it. The 5th action is 2 things. One is fast, the other surprises everyone I raise it with. The first part is your council rates and utility concessions. Every state and territory offers concessions for pensioners on council rates, water rates, vehicle registration and energy bills. When you have big life changes, like when a spouse dies or you transition from working to pensioner, in this period the rates notice doesn't exactly update itself. Ring your local council and your utilities provider to ask whether your concessions reflect your situation. Most calls take 15 minutes. And the savings on a single property over a decade can run into thousands of dollars. Now, the second part, and this is the one that bugs me most when I see it happen to people. A mortgage-free home in Australia is not automatically protected from your creditors. If a creditor, a personal loan company, or even the ATO in some circumstances, obtains a judgment against you, they can apply to the court for what's known as a writ of execution against real property. That writ, once registered against your title at the land registry, secures the debt against your home. When you eventually sell, or when the property passes through your estate, the creditor is paid out of your equity before anyone else sees a dollar. I've sat across from people who had no clue this was possible. I know a man called Andrew, 68, retired tradie. He had credit card debts from a tough year in his early 60s when his business closed down. A default judgment had been entered against him because he hadn't responded to the original claim. The claim had sat in a pile on the hallway table for months, and he avoided thinking about it. A writ was registered against his home while he was living in it. He thought the house was untouchable because he owned it outright. He was wrong. If a court claim arrives at your house, do not put it in a drawer. Respond, even if only to acknowledge it and ask for time. If you receive a default judgment, contact a free financial counsellor through the National Debt Helpline on 1-800-007-007, weekdays from 9:30 to 4:30 p.m. That service exists, it's free, and it's exactly what it's there for. And if you want to know what is currently registered against your property, you can do a title search from your state land titles office for around $20 to $40. Any registered charges, caveats, or writs will be listed there. That's it. 5 actions, all doing the same thing. Making sure that a home you have spent decades paying for can't be quietly taken away from you. Here's a recap of the 5 actions. The state title alert from your land registry. Do it today.
The owner lodged caveat on your title. The enduring power of attorney.
Find out today how your home is legally held. Most people don't know off the top of their head, and the answer matters more than you'd think. The rates concessions check. And do not ignore creditors or overdue bills. I am not a financial planner, a solicitor, or a regulated advisor. This video is general information based on my experience inside the system. For your specific situation, please speak with a solicitor in your state. The rules in your state may differ in important ways from the figures and processes described in this video. Take good care of your home, and I'll see you next time.